I've ruled on the motions as required by law.
Without any kind of conclusion of law in them, just denied. Does that not show a bias and a prejudice against one single person?
All right. Are you done?
Are you not going to recuse yourself?
No, I'm denying your motion. Anything else?
Good evening, beautiful humans. Welcome to the Midlife Revolution. I'm your host, Megan Connor, and I have to admit, I am feeling a little snarky this evening. We have got seven new documents to go over this evening. I have realized that I'm behind the queue. I know lots of people have covered this already. I know that a lot of the documents and commentary are out there already. I wanted to wait until I had all of the responses and emotions and everything before I went live with this. And so tonight I'm going to go over 7 new documents. Are you ready? We're going to recap Lori's motion for a new trial. We're going to recap that just briefly, and then we're going to go over these in order. Lori's motion to dismiss for non-preservation of evidence and the state's response. Then we're going to go over Lori's motion to preclude the phone data and the state's response. Then we're going to go over non-preservation, phone data. Then we're going to go over Lori's motion to suppress the evidence related to the Jeep Wrangler. Then we're going to go over the state's response to suppress the Jeep evidence. And then we're going to go over the minute entry where Judge Beresky, yes, I'm going to just give it away right now, Judge Beresky denies Lori Daybell's request for a new trial. So, I hate chocolate. I think this is great. Lori's prison library is surely missing some materials. I think, yes, she is missing out on a few things. I have to tell you, just as a little bit of an update today, guys, in the midst of dealing with, Lori's stuff, a little bit of drama went down in the podcasting world, and specifically in the ex-Mormon podcasting world. And 2 of my very dear friends removed their YouTube channels over the last couple of days. And earlier today, I interviewed one of them, and I will be posting that video tomorrow. There has been some cyberbullying going on, and indeed, I would even call it terrorism, because there's a specific group of people that is terrorizing some ex-Mormon content creators, and I am not happy about it. I get upset anytime I see injustice in the world, and I wanted to show up for my friends. And so the reason I'm feeling quite snarky this evening is not only because of Lori's issues, but because of the drama that's going on behind the scenes. I normally don't like drama. I don't like to get involved, but this is a situation where I feel like people have been unjustly silenced. And that's a place where I am always going to enter the fray. So fresh off of recording the 2-hour episode that I did with my dear friend, Jenny, tomorrow that episode is going to drop. So you'll be able to hear everything that's going on. My friend Jenny is a domestic abuse survivor, and she speaks honestly and openly online about her experience, and also, about her experience in the Mormon church. And because she is openly ex-Mormon, there are some Mormon content creators who have thrown some shade and some hate her way. And it's honestly really angering, because she's a good person. She's out here helping other domestic violence survivors, and Mormons don't like that she is critical of the church. And for that reason, they basically did 2 episodes dragging her when she stated she was having a mental health crisis because of all the negativity she's receiving online, which I think is out of bounds. It's offsides. And so I'm going to comment on it. So that's why I'm feeling a little bit snarky this evening. Carmela, thank you so much. This is so kind of you. Thank you. I appreciate it. And also, guys, it's a little bit of a celebration tonight, because if you didn't know this, I released a video detailing Lori's basically kind of origin story, or family of origin, Barry Cox, and the divorce between Stacy and Stephen, how that shaped Melanie, who is a key player in this upcoming trial. And that video has over 100,000 views. And I just want to say thank you. Thank you to all of you who have watched it, all of you who especially have shared it with people, all of you who liked the video. Thank you so much for that support. It was a lot of research and time on my part. I wanted to make sure that I had documentation and receipts, and I really did the best that I could to make sure that everything that I showed was publicly available and factual. I did offer some of my own personal opinions and some of my own personal experiences. I hope that I was fair and balanced. And so I just want to say thank you to everybody who watched it and shared it and liked it. Of course, it's the biggest video on my channel. And it is amazing that a little channel like mine with less than 20,000 subscribers got 100,000 views on a video. So thank you so much. Thank you so much for all of you who have supported me. Now let's get to it, because I want to get this stuff done before Web Sleuth goes live later tonight. I'm going to be in the chat over there because I love that channel. Sorry, guys. I just have to get comfy. Thank you so much. And thanks to everybody who is supporting in the chat. And thanks to all of you who have supported my channel over the course of, these crazy trial coverage situations. I will be covering the Brandon Boudreaux trial. I will be doing so right here from my comfy chair. And I'll be live streaming the trial coverage, as well as doing a afternoon recap, a midday recap, and then a recap at the end of the day, just like I did when I was there in Arizona, except that I will be here with my dogs and my kiddos. My youngest daughter is just about to finish school for the year, and summer break for her. So I didn't want to leave her here while I went to Arizona, and I definitely did not want to drag her to Arizona in the summer heat to go through trial when I was going to be gone all day. Jerry Vallow, great to see you here. Thank you so much for being here. We got the bish. We're going to keep getting her. So I'm grateful to all of you who are here joining us. I'm going to show you these documents. Lisa, my thoughts are with you, dear. And to anybody else who is dealing with difficult circumstances right now, really appreciate you guys being here. Yes, thank you so much. And I'm always going to be on the side of safe care. Okay, so let me share my screen. I want to first recap Lori's motion for a new trial. So let's talk about that first, just for a second, because I did another video where I went over this in depth. So we're just going to recap it as quickly as we can. So first of all, Lori's asking for a new trial because of juror misconduct. If you guys missed it, Juror 15 gave an interview outside the courthouse just after the verdict was read, where he made a comment that he said he was thinking about Lori serving 3 life sentences on his way home yesterday. That was the day before the jury deliberated. So there was some question as to whether or not he had, in fact, Googled the case and learned some information. But he reiterated in an interview on Hidden True Crime that he knew nothing about the case prior to. Then Lori is asking for preclusion of Tylee Ryan and Alex Cox statements and impermissible expert testimony by Detective Daniel Coons. Lori is alleging that Alex Cox's statements on the walkthrough were important and needed to come in. She's argued this before. It's been ruled on before. I'm not sure why she's bringing up here again. And then C, on a discovery violation, the contents of the hard drive, the gray key evidence, that's what Lori is alleging, that it contains exculpatory evidence. In other words, evidence that would completely exonerate her. I just have to pause for a second to say that if you hear screaming in the background, My daughter and has a friend over, and they are playing a jump scare game. So I just want to put that out there. I don't know if you guys can hear her, but every once in a while I can hear her. There's a lot of loud noises coming from her bedroom. They're enjoying some friend time together. Everything is fine. So sorry. McSpunky, I'm glad you're here. Good to see you. I'm absolutely certain you guys heard that one. Sorry about that. But I'm not going to tell my kids they have to be quiet because I'm on a live stream. That's not fair. All right. So going back to Lori's, discovery violation about the gray key, and then prosecutorial misconduct, where Trina Kay asked a question of Captain Keller about him overhearing the defendant, Lori Daybell, say something about not getting invited to a pool party because of the commotion at the house. Lori is just saying that shouldn't have been admitted. But Lori, that's what objections are for. That's what cross-examination are for, blah, blah, blah. And then finally, she says, Ms. Trina Kay commented several times on this defendant's demeanor during this evidence drive to the police station. Body camera told the jury, you did not see her cry in that interview, yet knowing there are portions of this defendant's interview that had been cut from the full interview, admitted by the state where she sat in the room and did show emotion. She even reached for a Kleenex, everybody. That clearly shows she was emotional. And then court's lack of impartiality. If you haven't seen it already, the video where she asks the judge to recuse himself for his obvious personal bias, I'll play that little clip for you again here in a minute if we have some time. And then she puts her arguments and authority out there. So I just wanted to recap the things that she is asking for a new trial, because we are going to reference this motion when we go over what Judge Beresky responds. The last thing I want to just cover is that she referenced Judge Beresky's commentary when he overruled the state's objection to the testimony by Serena Sharp. And Judge Beresky commented, in as much as you're comparing yourself to these biblical figures, I'll allow it. And we're going to hear his response specifically on that. Now, the first thing that we're going to go to, and these are out of order on my X feed. So I just want to, I've got them in order here. The first one that we're going to go over is Lori's motion to dismiss the case for non-preservation of evidence. And just want to make sure. Here we go. Okay, so this again, we're back to handwritten motions, y'all. Apparently, Lori did not get enough time on her typewriter. And this is so true. Cindy Ranelli, so many of everybody are dealing with very difficult circumstances in one form or another. You'd never know what's going on in someone else's life. So please be kind. Be kind in the chat, as you guys always are. It's so good to see so many of you. I see so many names that I recognize from way back in the beginning of my podcast. And I just want to say thank you to all of you who have been here supporting me. McSpunky, please don't chat and drive. I'm not even going to show your comment. Y'all, let him drive. Okay, so this is Lori's motion to dismiss for non-preservation of crucial evidence, filed on the 14th of May. The defendant, Lori Daybell, requests this court dismiss the charge of Brandon's case, since the state of Arizona did not preserve the crucial evidence of the car door or the car window of the alleged victim. It's a violation of the 6th and 14th Amendment of the U.S. Constitution and the defendant's right to due process and the right to a fair trial. The lack of preservation of this critical evidence is prejudicial to this defendant's and her defense team. 1 second, guys. Okay, so just putting calming dogs down, basically. Okay. Yeah, are victims' cars supposed to be seized and stored for 5 years? I mean, let's note, I believe this was a rental car that Brandon was using, not even his actual own vehicle. And so, yeah, Barry Cox, non-Esquire, and Lori Daybell's Shadow Advisory Council. So true. So going back to this, the lack of preservation of this crucial evidence is prejudicial to this defendant and to her defense team. The defense has requested of the state the actual door of the car that was allegedly shot and the window of the car door that shattered as a result of the alleged gunshot. There's an actual door. Okay, just want to make sure. Okay, the defense was informed by the state that they do not have and did not preserve the car door or the window of the car door. Therefore, they are not available to the defense to do their own independent investigation of these two crucial pieces of evidence to this case. There are nothing but pictures of the car door and the car window. Therefore, the defense and its experts cannot measure or test anything about this alleged shooting. This is a violation of the state, precluding the defense from doing an independent investigation of this case, a violation of the defendant's 6th and 14th constitutional right, and calls for dismissal, complete dismissal of the whole case. Oh. Okay, so now we're going to go to the state's response for dismissal for non-preservation of crucial evidence. The state of Arizona, though through undersigned counsel, requests this court deny the defendant's motion to dismiss, since the Gilbert police did not act in bad faith when they decided not to preserve the Tesla and the Tesla driver's side window, and any testing of the Tesla or window would not exonerate this defendant against the action she took in Rexburg, Idaho, to aid in the charge of conspiracy to commit first-degree murder of Brandon Boudreaux. Facts. On October 2nd, 2019, Brandon Boudreaux was residing at, gives address. That morning, he left his residence at approximately 7:25 a.m., took his children to school, dropped off his youngest with his soon-to-be ex-wife, and went to the gym. Around 8:40 a.m., a neighbor was backing out of his driveway and observed a Jeep parked next to Boudreaux's driveway. The Jeep was parked so the front of the Jeep was facing the front of a white SUV. The neighbor noted that the Jeep was running. Oh, shoot. I clicked the wrong thing. Here we go. Had tinted windows and a Texas license plate. The neighbor had never seen the Jeep before. At approximately 8:48 a.m., another neighbor was walking his dogs when he saw a Jeep parked with the front of the Jeep facing the front of a white van in front of Boudreaux's residence. The neighbor noticed the Jeep was running, that the driver's seat was pushed all the way forward to the steering wheel, and he could not see in the back of the Jeep due to the tinted windows. Boudreaux returned home at approximately 9:13 a.m. As he approached his driveway, he slowed as his Tesla began opening the garage door. As Boudreaux slowed, he noticed a Jeep parked next to his driveway. Boudreaux watched as the rear window of the Jeep lifted up and a rifle barrel pointed out of the rear window. I can't even imagine how scared and anxious he must have been about this. This is terrifying. Boudreaux heard a loud bang and his driver's side window shattered. Boudreaux hit his gas and drove away from his house. Boudreaux called 911 and returned to his house. When Boudreaux put his Tesla in park, the driver's door automatically opened, and the driver's side glass window fell out of the frame and onto the driveway. When police arrived, they noticed the hole in the driver's door frame and the driver's side glass lying on the driveway. Police recognized the hole as being made by a bullet. Gilbert police detectives went to the scene, took photographs of the street where the shooting occurred, the glass in the street, the white van, an area around the white van that was mentioned by neighbors, the Tesla in the driveway, the gunshot hole in the door frame of the Tesla, and the driver's side window that was laying in the driveway. The police also took photos of the Tesla with a trajectory rod in the bullet hole and the bullet fragments that they collected from the door frame. The Gilbert police report and impound sheets showing that the Tesla and driver's side window were not impounded were disclosed to the defendant on December 12, 2023. So in other words, Lori, you've known about this for a long time, that the actual door and window were not available for testing since December of 23. On October 2nd, 2019, Lori Vallow and her co-conspirator Alex Cox were living in Rexburg, Idaho. In the days leading up to October 2nd, 2019, Lori Vallow provided her deceased husband's 2018 Jeep Wrangler to her co-conspirator Alex Cox to drive to Arizona to shoot Brandon Boudreaux. Before Alex Cox drove to Gilbert, Arizona, he took the 2018 Jeep Wrangler to a tint shop in Rexburg, Idaho, to tint the windows so no one would see him in the rear of the Jeep as he lay in wait for Boudreaux to return home. On October 1st, 2019, Lori Vallow rented a storage unit in Rexburg, Idaho. While Alex Cox was driving the Jeep to Arizona to shoot Boudreaux, Lori Vallow stored the Jeep's spare tire and rear bench seat in her storage unit. While Alex Cox was committing this shooting in Gilbert, Arizona, Lori Vallow Daybell was in possession of her co-conspirator's cell phone in Rexburg, Idaho. On October 2nd, 2019 at 8:02 a.m., the defendant used her co-conspirator's cell phone to call her cell phone to make it appear that her co-conspirator was in Rexburg, Idaho at the time of the shooting. The Due Process Clause of the 14th Amendment, as interpreted in Brady, makes the good or bad faith of the state irrelevant when the state fails to disclose to the defendant material exculpatory evidence. But we think the Due Process Clause requires a different result when we deal with the failure of the state to preserve evidentiary material of which no more can be said than that it could have been subjected to tests, the result of which might have exonerated the defendant. The failure of the police to refrigerate the clothing and to perform tests on this. Whoa, this is not the right. Well, okay, that was from the other case law. I was like, this is not the right case. I'm not going to read that word. This is what the other case held. The court stated, we therefore hold that unless a criminal defendant can show bad faith on the part of the police, failure to preserve useful evidence does not constitute a denial of due process of law. The defendant can argue that the police were negligent in not impounding the Tesla and or glass, but there is no bad faith in their decision not to impound the vehicle. No amount of testing on the Tesla by an expert would provide evidence that would exonerate the defendant from the action she was taking to aid her co-conspirator from Rexburg, Idaho. The conclusion is that the defendant has had the police reports that show the Gilbert police did not impound the Tesla since December 12th of 2023. The defendant has failed to show any bad faith on the part of the Gilbert police in their decision not to impound the Tesla or the glass window. The U.S. Supreme Court has held that failure to preserve useful evidence does not violate the defendant's due process rights. Here, the Gilbert police failed to preserve evidence that has extremely limited evidentiary value and no value to exonerate the defendant's actions that were occurring in another state. Therefore, the state requests this court deny the defendant's motion to dismiss. Okay, coming back in to check the chat here, guys. Please don't do any comments yet, any questions yet. Save your questions because I won't be able to see them in the chat because I can't watch chat and read at the same time. Thank you so much, C. Charles, for the super sticker. I appreciate you. Hey, it's good to know that thumbnail got some attention. As I said, I was feeling pretty snarky tonight, and that was why I did the thumbnail the way that I did. Dang it, you guys are asking questions. So I'm going to star them and come back, okay? Appreciate you guys. Thanks for being here. We're going to go through the next motion here in just a second. Just want to make sure that I don't miss anything super important. Yes, the trial starts on June 2nd. Actually, on the 29th of May is when they're going to start going over the jury questionnaires. So opening statements on June 2nd. Just scrolling quickly through chat to see, and I'm just starring questions as I go through chat, and then I will come back to them later because, again, I don't want to answer them before we get through all of this stuff. AA from AA, good to see you. Hazelnut, thank you so much for this super chat. I heard Brandon B. tell the female officer that first responded, there had to be two people in the Jeep because they got away too fast. Who was driving that Jeep with Alex in it? I don't know, but we do have that testimony from the neighbor that said that the seat was moved all the way forward. And so it would have been pretty difficult for there to be a driver if that seat was all the way forward. I'm not sure exactly how this all went down, guys, but this is the evidence that I'm looking forward to seeing in the trial. I don't think there was anyone with him, honestly. I think that he just really got in there quickly. So just quickly seeing Lori is 1 year older than me. And okay, I start everything else and I'm going back to, to the next motion here so that we can get through this quickly, guys. 8:57. I'm doing okay so far. All right, the next thing that we're going to go over is the motion to preclude the phone data. It's the Jeep one. Here's the phone data one. Okay, so this is Lori's motion to preclude evidence of phone data and text messages. The defendant, Lori Daybell, I'm doing these in order of when they were filed, guys. So her filings and then the state's, her filings in the order she filed them and the state's responses. And then at the end, we'll go over the judge's denial of her new trial request. The defendant, Lori Daybell, requests this court preclude all evidence of phone data and text messages relating to Alex Cox, pursuant to the Rule 801C hearsay, Rule 801D, unless it is defined a non-hearsay under Rules of Evidence, Rule 803. In order for text messages to be relevant, it must establish the defendant's intent, knowledge, and absence of mistakes. The alleged co-conspirator is deceased. Therefore, the state cannot establish Alex Cox's intent, knowledge, or absence of mistakes. Facts. In Olmstead, telephone messages are inadmissible. B, Federal Wiretap Act, use of constitutionality, Article 111. Number 2, State Invasion Privacy Act, prohibit unlawful access to stored electronic oral communications, RE. I can't read that word. Facebook, RE Facebook. And that, so I think that what probably happened is that Lori hand wrote these motions thinking that either her paralegal or her one of her advisory counsel would type up this motion and file it. And so I think that's the reason why she's being a little bit brief in what she's saying here, but apparently they didn't have time to get that done. So C, torts. IPA bars reading or attempt reading of any message. The data contained is unreasonable. Servers, web, I can't read that word, web boost or web lost are overseen breaching foreign treaties. D, Pixel tracks IP addresses and devices. 1D, violating USCA Constitution Article 3, number 2. E, in RE, search warrant application for location information violates pen register and tap and trace. Cell site location info, Stored Communication Act. SCA does not permit government to obtain requested ping warrant. In Olmstead, proves under Wiretap Act, the telephone messages cannot be intercepted. A warrant cannot be provided. In Riley, data goes to cloud computing and server. Server connects to a web blast, which something are foreign entities, which must or which cast. Web host opens to Pixel. Pixel tracks the device, servers, web hosts, pixels, data, and cloud computing could take numerous court orders. Therefore, the data was illegally obtained. And according to Riley v. California, it is hearsay anyway. So, I think Lori is just kind of paraphrasing there to give the general idea and hoping someone else is going to type this up better, but they didn't. Also, if the state is using geofencing from Google or location history directly from the account, the state still, underlined in all caps, cannot determine who was in control over that device at the time. So any data obtained would be pure speculation as to an actual person's location. A phone is a small device that can be picked up by any person and transported by any person. The state has made no determination, underlined, to the defense that any data turned over to the defense regarding Alex Cox is actually data from Alex Cox. Any person who knows your email address could purchase a phone and attach your email address to it. Yeah, but only if they have the password also. The defense requests this court preclude all evidence of phone data regarding Alex Cox in this trial for all of the reasons stated above. And then I will check chat again here real quick before we go to the state's Response, yes, Northwest. I'm confident phone data was obtained legally, was admitted in 2 previous trials. Exactly. Thank you. Starring a couple of comments here, questions real quick. Yes, please take a second and like it. I would appreciate it. It'll get out to more people who want to see it. The neighbor reported that the driver's seat was all the way forward so that there would be room in the back. So, okay, going on back over, guys, sorry. She just whining because she ain't winning. I like that. I love the liberal use of caps and underlines. It's like, I don't know what it's like, a 13-year-old writing a letter to a friend or an enemy, I suppose. True. Hey there, Latter Daily Digest. Good to see you. A phone is a small device, y'all. It can go anywhere. Yeah, and that's one of the reasons why the cast agent, and I believe it was Agent Balance that testified in Chad Daybell's trial, he was very careful to say that Chad's device or Alex's device was in a location, not that they personally were. And then it's up to the jury to make the decision whether or not that person was also in the location along with the device. Okay, so now I'm going to go back to the state's response to preclude evidence of data and text messages. So this is Trina K's response to Lori's motion to preclude the phone data that we just read. The state of Arizona requests this court deny the defendant's motion to preclude text messages, iCloud data, cell tower data, and homerjmaximus@gmail.com. By the way, that's a Simpsons reference, guys, in case you didn't know. This evidence and data were obtained pursuant to search warrants, and the text messages are admissible pursuant to Arizona Rules of Evidence Rule 801D, 2A, and E as statements by a party opponent. On October 10th, 2019, Gilbert Police Department obtained a search warrant for a Verizon number and gives the number, 9120. That's Alex's. On December 3rd, 2019, Gilbert Police Department obtained search warrant, gives the number, for Verizon track phones ending in 4652 and 9120. On February 26, 2020, Gilbert Police Department obtained a search warrant for track phone ending in 5998. On December 5th, 2019, Chandler Police Department obtained search warrant, gives the number, for Lori4Style at iCloud.com. On March 30th, Chandler Police Department obtained a second search warrant for Lori4Style at iCloud.com. Excuse me. So they have to have a different warrant for each of the types of data that they're going to extract from those iCloud accounts. On January 15th, 2020, Rexburg Police Department obtained search warrant for Homer J. Maximus at gmail.com. All of the evidence the defendant seeks to preclude was lawfully obtained through multiple search warrants. Here are the receipts, the end. That was actually filed by Rachel H. Mitchell, who is on the prosecution team with Trina K. Okay, next, 4 down, 3 to go. Guys, we're getting there. Lori Vallow's motion to suppress the Jeep evidence. Here we go. Pursuant to the 4th Amendment of the U.S. and Arizona Constitutions, the defendant, Lori Daybell, requests this court suppress all evidence obtained as a result of illegal, unconstitutional warrantless service of the Jeep Wrangler with the license plate. Facts. On or about October 17th, 2024, approximately 7 months ago, Detective Ray Hermosillo of the Rexburg, Idaho Police Department, which, by the way, shout out to Ray. He's done a great job. Met him at the last trial, and I stand Ray Hermosillo. A state witness intended to testify in this trial was interviewed on a podcast entitled Fax Me That Podcast. I'll have to look that one up. During this 2-hour, 12-minute interview featuring Detective Hermosillo, the detective informs the public how he obtained the Jeep Wrangler. On November 4th, 2019. Detective Hermosillo indicates at or about 5 minutes in that 1. On Monday morning on May 4th, 2019, while driving home from the gym, he spots the Jeep in an apartment complex parking lot. 2. He makes some phone calls and gets the Jeep impounded. 3. He then gets on the phone with the Arizona and states to, quote, "I got your Jeep." 4. Arizona says, "Hang tight, we have to get a warrant issued." 5. Detective Hermosillo then states, "That Jeep sat in our custody a week and a half till they showed up." Conclusion. So after seizing the Jeep Wrangler without a warrant, Detective Hermosillo then took steps to obtain a warrant. The defense requests all evidence obtained as a result of this unconstitutional warrantless seizure in violation of the Fourth Amendment be suppressed. A suppression hearing is requested. It says today's date and signature, but we don't have that. Ostensibly, there was a signed copy of some kind that's submitted to the court. So now I'm going to go to the state's response to the defendant's motion to suppress all evidence pertaining to the Jeep Wrangler. The state of Arizona requests this court deny the defendant's motion to suppress all evidence pertaining to the Jeep since the Jeep was lawfully seized and impounded pursuant to a search warrant. On November 1st, 2019, Detective Ray Hermosillo with the Rexburg Police Department spoke with Detective Nolan McDermott from the Gilbert Police Department. Detective McDermott sent a probable cause statement to Detective Hermosillo, providing probable cause to seize the 2018 Jeep Wrangler, gives the license plate and VIN number. Detective Hermosillo went to the court on November 1st, 2019, and obtained a search warrant. Detective Hermosillo documented that he obtained a search warrant for the Jeep on November 1st, 2019, in his police report. The state recently obtained a copy of Search Warrant 2019-60 and disclosed that to the defendant. So there you go. You have your disclosure, Lori. On November 4th, 2019, Detective Hermosillo observed the 2018 Jeep Wrangler at 565 Pioneer Road in Rexburg, Idaho. Detective Hermosillo had probable cause from Gilbert Police Department that the Jeep was used in the shooting in Gilbert, Arizona. He knew that the Jeep was movable and could be driven away, and he had lawful authority to seize the Jeep pursuant to the search warrant that he obtained on November 1st. Detective Hermosillo documented in his police report that he seized the Jeep on November 4th, 2019, and had it towed to the Rexburg Police Department. Upon seizing the Jeep, Detective Hermosillo realized his original warrant contained the correct VIN number, the correct model for the Jeep, and the correct license plate number for the Jeep, but there was a typographical error as to the year. Search Warrant 2019-60 indicated the Jeep was a 2008 instead of a 2018 Jeep Wrangler. Detective Hermosillo immediately obtained another search warrant for the Jeep Wrangler. Search Warrant 2019-61 referenced the typo in Search Warrant number 60. A copy of Search Warrant 2019-61 and Detective Hermosillo's police report that provided this information was disclosed to the defendant on February 26th of 2024. Although Detective Hermosillo could have lawfully seized the 2018 Jeep Wrangler based upon the probable cause provided by the Gilbert Police Department, he did in fact seize the 2018 Jeep Wrangler pursuant to a search warrant that he obtained on November 1st, 2019, 3 days before the seizure of the Jeep. Quote, merely innocent or negligent mistakes in an affidavit will not satisfy the first prong of the Franks test. In this case, Detective Hermosillo's affidavit in support of Search Warrant 2019-60 contained a factual basis to seize the Jeep. The Jeep's correct VIN, the Jeep's correct license plate number, the Jeep's correct model, and the Jeep's correct color. The typographical error of indicating this was a 2008 Jeep instead of a 2018 Jeep does not invalidate the search warrant. Furthermore, upon noting this error, Detective Hermosillo obtained another search warrant to correct the mistake. The 2018 Jeep Wrangler was lawfully seized pursuant to a search warrant. The state requests this court deny the defendant's motion to suppress all evidence pertaining to the Jeep Wrangler. Submitted May 15th. These are excellent arguments on Trina Kay's part, and it just seems like Lori lacks a basic understanding of how to make these arguments in court. I wonder if she was like Regina George. Yes, in North Wildings, if you sat through Chad's trial, you would have heard how incredibly stupid they were with their phones. They clearly never followed true crime. Although I do have to note, Lori and Chad were a lot better at logging out or at least turning off their location services on their phones than Alex was. And it makes me think that Chad and Lori did not give Alex a heads up to say, hey, you might want to turn off the location service when you're committing a crime, because they had Alex in a lot more ping places than they did Lori and Chad. Although I will just put this out there, one of the reasons we got so much evidence is because they were dumb enough to log into their burner phones. They were dumb enough to log their burner phones into their iCloud and Gmail addresses, etc. So, anyway, I'm just going to take a look to see if there's any questions that I need to. I'm just starring questions, anything that has a question mark. Thank you so much, Cindy Ranelli, for the super sticker. Appreciate you. And Thunder Snow, but Lori has no style. So how could it be Lori for style when Lori's clearly against style? Yeah, it seems like this whole group of people really liked to make their references to pop culture and movie quotes and all of that. And don't get me wrong, I love movie quotes too, but I don't think I did it to this extent. This is true. Jury gets to decide, do these locations at these times make more sense in a world where this set of events happens or another set of events? Yeah, find new tactics, Lori, for sure. Just looking for more questions to star real quick before I go back to the next one. This is entirely possible. I know that there definitely are people out there who don't like me, who are watching the videos just to see if I slip up, and that's totally fine. You guys are welcome to be here. Catch me if you can. Call me out. Just looking for some more questions over here, guys. And thank you guys for being here and supporting each other. And thank you for answering each other's questions while I'm reading stuff. Lacks a basic understanding of facts. I agree. This is a good comment, and I have a lot of consternation about this too, Justine. And I hope they do charge her. I think there is enough evidence to charge her, but I don't know that for sure. I'm going to star a couple more things here, guys, before I go back to the last couple of things. I'm trying to get done quickly so that I don't step on Web Sleuth's YouTube live, because I like them. And I like hanging out there with their mad chatters. Okay, so the next thing that we're going to go to, I have this on a list here, guys. 1, 2, 3, 4, 5, 6. Okay, so we're there. It's time for the minute entry. I'm so excited. I'm so excited to read this from Judge Beresky, you guys. And stay tuned for my little outro video that lasts 3 seconds long. I think you'll appreciate it. Okay, here is the minute entry. That Judge Beresky he's going to address everything that Lori put out in her motion for a new trial, which was filed on May 1st. He's going to address the state's response and the defendant's reply to the state's response. You know, that's the other thing. That was the other thing I didn't get. Shoot. There was a reply. So give me just a second, guys. Lori did a reply to the state's response. To her asking for a new trial. So let me look at that real quick. Defendant's motion to preclude, et cetera, et cetera. Okay, I'm going back to make sure that I didn't miss anything. We went over the phone and the Jeep and non-preservation of evidence. I think what I'm missing is the state's response to Lori's request for a new trial prior to the judge's minute entry. Shoot, I guess I don't have that one. I thought I had all of my stuff together, guys. I apologize. Oh, I do have that one. Okay, here we go. 1 second, here we go. Okay, now I show these documents here just in case anybody wants to see that I do in fact have the receipts. I know some of you are not watching, you're just listening, and that's fine. But they're here, and if you want to pause it and read them for yourself, they're here. I do this for full transparency. So the state of Arizona requests this court deny defendant's motion for a new trial as there was no juror misconduct, no prosecutorial misconduct, no improper exclusion of hearsay testimony, and no lack of impartiality by the court. The state's response is supported by the attached memorandum of facts and authority. So I went through this when I did the video on Lori's request for a new trial. We played all of these clips from the juror misconduct allegations, and the state's response thoroughly goes over the fact that the juror did not know any information about this trial prior to. They referenced several clips from the Hidden True Crime interview that was done, and I played those clips in that video, but I just wanted to recap this for you guys so that you have the state's response before we read the minute entry. Then the Tylee Ryan and Alex Cox statements appropriately precluded as hearsay. And then the state said the court ultimately precluded any statements by Alex Cox to the police from both when the police arrived 47 minutes after the shooting, as well as the statements he made at the police station a couple of hours after the murder. And then Detective Coons was noticed by the state as an expert witness to discuss the trajectory of the shots at the crime scene. Therefore, they didn't need to bring in the walkthrough. Defendant never established a foundation that any statements made by Alex Cox or Tylee Ryan hours after the shooting were admissible under any of the Arizona rules of evidence. She did not put up a fight about this, and she didn't call any witnesses. There was no discovery violation. Trina K goes through this, asking about Lonnie Dworkin continuance to allow time for her expert, but then she didn't want to continue and she wanted the speedy trial. And so just going through all of that, the defendant emailed a motion to dismiss for failure to disclose during the trial and for prosecutorial misconduct, but the motion provided no facts to support that any exculpatory evidence existed. And so that's basically Trina K responding to all of that. And then there was no prosecutorial misconduct. The jury was advised that in their opening statements, the prosecutor and defendant talked to you about the law and evidence. In a few minutes, the prosecutor and defendant will give their closing arguments and we'll talk about the law and the evidence. What they said or say is not evidence because it's not sworn testimony, but it may help you understand the law and the evidence. And then they were given instructions regarding self-defense. She addresses the defendant's demeanor, etc. And then the court remained impartial before, during, and after trial. And Trina K outlines how impartial the court was, how patient the court was with her in all of her filings and her inept subpoenas, etc., etc. So I just wanted to make sure we went over that before we finally read this minute entry here by Judge Beresky. This is supposed to be on my Twitter page, but apparently I wandered over to Justin Lum's. I always appreciate Justin Lum. He's been on this case since day one, and he is an excellent source for all of this information. But it looks like I have lost. Okay, I'm going to go over to mine now to see, because I know I have it in the right place. Here it is. the minute entry. Okay, here we go. The court has received and reviewed the defendant's motion for a new trial, the state's response, the defendant's reply to the state's response, which that's the one that I don't have. A, juror misconduct. The defendant alleges there was juror misconduct based on a statement juror 15 made to reporters following the verdict, wherein he stated, "You know, I feel sorry for her." Clicked the wrong thing. Driving home yesterday, I was like, God, she's spending the next 3 lives in prison in a cell. On its face, this statement would seem to indicate the juror violated the admonition and researched the defendant acquiring knowledge about her sentence imposed in another matter prior to, sorry guys, prior to the lifting of the admonition. However, the state's response included multiple additional media clips of statements juror 15 made both immediately prior to, after the statement referenced herein above, in every one of which he specifically denies any knowledge of the defendant's other case or sentence prior to the court releasing the jurors from the admonition. At best, juror 15 gave a single statement which seems to be in conflict with all of his other statements when he specifically denied any misconduct. And footnote 1, even if there was misconduct, the defendant's own motion undercuts her argument that the prejudice exists because she points out juror 15 stated he was leaning toward not guilty through deliberations, a distinct indication that if juror 15 did have any extraneous information at that time, it did not affect his consideration of the evidence. Here, on the limited record of the pleadings before the court, there being no affidavits or sworn testimony evidencing any misconduct as contemplated by Rule 24.1D2, the court does not find a clear indication of juror misconduct, let alone any evidence of prejudice to the defendant. Juror misconduct requires a new trial only if the defendant shows actual prejudice or if it can fairly be presumed from the facts. B, preclusion of Tylee Ryan and Alex Cox statements and impermissible testimony by Detective Daniel Coons. The court issued a preliminary pretrial ruling on March 11th regarding the inadmissibility of statements made by Tylee Ryan and Alex Cox. The court's ruling stated that out-of-court statements made by Tylee Ryan and Alex Cox appeared to be non-hearsay or fell within an exception to the rule excluding hearsay. The court went on to give the defendant the opportunity to offer specific statements at the trial by stating the defendant could re-urge the issue outside the presence of the jury. Not only did the defendant never take the court up on its offering during trial, the defendant's motion for new trial and reply only argue in generalities, failing to set forth any specific statement that should have been admitted into evidence under either a non-hearsay exemption or an exception to the hearsay rule. As to Detective Coons' testimony, the defendant argues that the detective did not have foundation to testify as an expert. Sufficient foundation was laid for the detective to give his opinion, and the defendant has offered no specific information as to what additional foundation should have been required. To the extent the defendant believed the witness was not qualified or his opinion should not be given weight by the jury, she had the opportunity to cross-examine the witness about his qualifications or lack thereof, as well as the basis for his opinion. And then, footnote 2 says neither the state nor the defense chose to have an affidavit prepared by juror 15 or any other juror, so the court is left with the media clips provided from the pleadings. There you go. Wrong page here there for me, guys. Sorry about that. Okay. The defendant also argues she did not have time to rebut Detective Coons' testimony. The record is clear that the defendant was offered more time to prepare for trial and declined. Moreover, the argument that the basis of Detective Coons' testimony was the walkthrough of Alex Cox is not supported by the record. The defendant's reply, for the first time, raises the additional argument that Tylee Ryan's statements also formed the basis for Detective Coons' testimony. Again, there is no evidence of this, and the defendant offers no specific statement by Tylee Ryan or Alex Cox to support her assertion. Even if what Alex Cox and or Tylee Ryan told Detective Coons somehow contributed to his opinion, the defendant never asked the detective those questions. For example, did anything Alex Cox show you or tell you contribute to your opinion? This type of question would have been permissible. However, the defendant did not ask it, nor was she ever precluded from asking it. The court finds the statements of Tylee Ryan and Alex Cox were properly excluded, and the defendant has failed to raise a single specific statement that should have been permissibly allowed under the rules of evidence, nor has the defendant established Detective Kuhn's testimony was improper. C, discovery violation. Although defendant's motion alleges the contents of the hard drive are exculpatory, she never articulates any single item whatsoever that would constitute exculpatory evidence. Again, merely stating something is exculpatory does not make it so. The defendant's request for additional discovery related to Charles Vallow's phone was accommodated. The state had previously disclosed all evidence it had in its possession at that time. The defendant requested access to the actual phone to run a new examination with software that had been updated since the phone was examined several years ago. The defense has offered no evidence that any additional information was obtained from the phone, let alone it being exculpatory. The court finds no discovery violation. D, prosecutorial misconduct. The court finds nothing in the defendant's allegations come close to establishing prosecutorial misconduct. The state is allowed to argue reasonable inferences from the evidence presented. The defense does not have to agree with those inferences and is permitted to argue the evidence should be interpreted differently. The defendant argues in her reply for the first time that both the state and the court violated the defendant's rights under the Religious Freedom Restoration Act. Although new arguments are not to be considered when first raised in a reply, the court will nonetheless, and these are my words, over-accommodate you, Lori, as it has always done. The court will address this. The Religious Freedom Act protects religious freedom and prohibits the government from substantially burdening a person's exercise of religion. There is no conduct by either the state or the court that somehow infringed by either the state or the court that somehow infringed on the defendant's freedom to practice her religion, nor is there anything about the trial that impacts the defendant's freedom to believe whatever it is she chooses to believe. Moreover, the RFRA does not protect someone from committing criminal acts in the name of religion, nor does the RFRA prevent any person from disagreeing with another's belief system. Here, different witnesses may have had different interpretations regarding who Nephi was or the significance of his story. The defendant had an opportunity to cross-examine those witnesses regarding the same. None of this infringes on the defendant's religious freedom. For these reasons, the court finds no prosecutorial misconduct. E, court's lack of impartiality. The defendant alleges the court was not impartial because the court struck two of the defendant's witnesses from the defendant's witness list. And footnote 3 says, the defendant's reply seems to argue that the defendant was precluded from calling all 12 of her witnesses, which is not the case. The defendant chose not to call any witnesses during the defendant's case in chief. Contrary to the defendant's assertion that no rule of law or evidence requires her to establish a witness has relevant information, Arizona rules of evidence 601 and 602 require just that. Prior to trial, the defendant was given an opportunity to make a general offer of proof as to what relevant information the witnesses would provide, which the defendant was unable to provide. Unwilling, I'm going to say, was unwilling. When the court precluded the witnesses, the defendant was also advised by the court that during the course of the trial, if she believed these witnesses had relevant information, the court would revisit the issue. Therefore, the defendant did not again offer any witnesses, even though she was specifically told she could re-urge the issue. In addition, in her motion for new trial, the defendant offers no further information on what testimony the witnesses would have given if they were permitted to be called as witnesses. The defendant also argues the court demonstrated a bias based on the court's comment made while overruling the state's objection during the defendant's questioning of Serena Sharp. The state was objecting to the relevance of the question, and the court thought the question had some minimal relevance based on the context of the defendant's line of questioning. The court notes the defendant's argument as to why the question was relevant was not in line with why the court surmised it was relevant. While the court's comment was not necessary, and the comment he made was, in as much as you're comparing yourself to these biblical figures, I'll allow it, it does not evidence bias, nor does it mean the court was demonstrating any partiality. Nonetheless, we're missing the end of this. Oh no. I think it's referenced in another spot here on Justin's Twitter. Maybe? Thought I saw a separate page. Here it is. Nonetheless, the court acknowledges that the court's comment was unnecessary, and the court should have simply overruled the state's objection without comment. Moreover, the court has been presented no evidence whatsoever that this comment influenced the jurors. Having carefully considered the defendant's arguments, all of the briefing, and the record, the court finds that the defendant received a fair and impartial jury trial, and the defendant has failed to establish any ground for a new trial under Arizona Criminal Code 24.1c. It is ordered denying the defendant's motion for a new trial, which was filed May 1st, 2025. So there you have it. The judge has denied yet another motion. So I'm just going to skim here again, guys, looking for more questions. I will star them and then answer them. Judge Beresky is very, very measured. And also, I can give lots of reasons why Melanie Gibb and Zulema Pastenis would be relevant to the trial. I don't know why Lori couldn't come up with that. I know she just doesn't really want to be held accountable for it. And I agree. It's amazing how hard she's fighting to win at the same time, constantly screwing herself over. Just crazy. I'm trying really hard, guys, just to look for questions and not to read other stuff. But sometimes it's hard because I have that compulsion to read everything that I see. Okay. Sorry, guys. I'm starting to get sucked into chat. I'm trying really hard not to. I always want to see what you guys are talking about, and I want to join the conversation. So I'm just looking for questions now, trying really hard to just look for questions. And I'm almost to the bottom of chat here. So you were dumb to ask, Lori. Hey, Miss Mojo Rising, good to see you. Thanks for being a member for 10 months. Super cool. Yes, exactly. This part is so weird. Why couldn't she just make something up to justify her witnesses? And she tried to. It'll become apparent when I ask them what their relevance is. Now you need to say, what are you going to ask them? This is funny, but I really don't want a shirt with Lori's ugly face on it. Sorry, that was mean. Is it ugly? I shouldn't have said ugly. I just should have said guilty, her guilty face all over it. Okay. Almost there. You guys are chatting too fast, which is fine. Okay. There's another question. I'm glad you guys are here live with me. I appreciate you. Okay. Here we go. Again, thank you guys so much for the super chats and everything. So Natalie Cassidy, do lawyers like having to be involved with cases that are pro se, as Lori's is doing? I doubt it, to be honest with you. I don't know the real answer to this question, but I think it would be a burden to try and help a pro se defendant because there's so much that they don't know. Did they decide yes or no about her latest conviction being told to the jury? They haven't decided on that as far as I know. Trina K filed that initial motion and then she withdrew it and amended it. And I believe in the amendment, the only thing that she wanted to reference was count 4, which was fraud by deception. So the judge hasn't ruled on that yet. And I assume that that's going to come up when they meet on the 29th for jury selection. So I'm hoping that we'll find out at that point. Jermaine, Megan, do you have any clue from your convo with Brandon's wife if they're aware of Steve and Stacy's divorce documents? I can't fathom how a judge could ever allow Barry and Janice access to those kids. Well, so when you're in a custody situation and custody is disputed, if you decide to do a custody evaluation, which I believe was done in Brandon Boudreaux's case, generally speaking, both parties are subject to a mental health evaluation. And then the custody evaluator generally interviews all of the parties involved. For example, I was interviewed for my partner's custody evaluation because I spend time around his kids. So, but legally, what they can do and what they can include in those interviews, unfortunately, it comes down to the standard of good enough parenting. And if the judge perceived that Melanie did not present a clear threat to the safety and well-being of the kids, then the judge is not going to prevent the biological mother from seeing her children. And they only recommend supervision usually in cases where a parent has been convicted of an extreme offense like SA of a child or endangerment of a child or drug convictions, et cetera. So the standard is really, really high to remove any kind of parental rights or to have visitation be supervised because it's such a burden for the state. So unfortunately, if Melanie was able to convince a judge that she no longer believes any of this Lori stuff, if Barry and Janice were able to, not a judge, but a custody evaluator, if they were able to convince a custody evaluator that they don't pose a threat to the kids and that they don't subscribe to any of Lori's beliefs, then the court is really bound to the opinion of the custody evaluator. And each side can bring their own evaluator if they want to, one rebutting the findings of another. But again, they're just precluded from making a determination about custody that is not in favor of the biological parents unless they have a really good legal reason. So unfortunately, I think that's where we stand at this point. So if you can imagine in the Jeep, the driver's seat moving. So let's say this is the driver's seat and this is the steering wheel. You move the driver's seat all the way forward to the steering wheel so that there's more space in the back to lie down. I think that's what they were talking about. And yes, Lee T, this is correct. Alex added tint to the Jeep just like 2 days before, I think the day before or 2 days before he drove it down there, allegedly, to Arizona. And they're going to show the evidence of that. I'm assuming Trina K referenced it in her argument there. But I digress. As a survivor of child abuse who was labeled an abrasive B for taking a hard stand in defense of my siblings, I absolutely love your "oh no they didn't" energy. Keep being loud. Thank you. I really appreciate this. I'm not sure why I starred this. I just saw it as I was going by. But yeah, I when there is injustice, I want to speak up about it. There is a warrior princess part of me, honestly, that I have to rein in a little bit, because when the warrior princess part of me witnesses injustice, especially when it is a person in a position of power who is bullying a person who is in a weaker position, the warrior princess part of me wants to go and burn everything to the ground. And I have to say to her, thank you so much for showing up and being so passionate about defending the defenseless people. But let's take a little bit of a more measured response and not burn everything to the ground. Maybe just have a little fire in the fire pit over there. So anyway, Michelle says, do we wonder if she will eventually say that she didn't have sound assistance with her team, using that as another card to play for an appeal? Well, the judge already ruled when he appointed her as per counsel or as defending herself. He already went over that with her, that this invalidates her right to argue for an appeal on the basis of ineffective counsel. So she cannot go back now and say, I had ineffective counsel, because she is the counsel. Those attorneys are only her advisory counsel, and she's not allowed to get a new trial or to appeal based on that. So she just can't do that. It's already been addressed. Lee T, important question. Since you got to meet Lieutenant Hermosillo in person, what were his arm tats? I have to say I did observe them. I did not make notes specifically of what they were. So when I see him at the sentencing, I'll have to pay closer attention. Stuck on strings. I wonder how Alex did pew pew and get in the driver's seat so quickly to drive off. I do too. I don't know exactly. I do know that when you're in a traumatic or stressful situation, it can seem like time slows down. Brandon noted that the Jeep drove off so fast, but here's the thing, he drove off really quickly. And so I don't know, I'm just waiting for the evidence on all of this to get a better handle on the time frame and how all of that happened. If there is evidence of a second person in the car, I'm sure we're going to see it, because Alex was caught on several traffic cams. And if there was another person, for example, a passenger or something, we would see that there. Jermaine setting him up to be the fall guy, but why does she never throw Alex under the bus? I'm perplexed. Well, Alex was her protector. And also she had a fondness for Alex. And I don't know if any of you guys have noticed this or if this is just me. When she's in the interview room with Detective Inclan in the Arizona Police Department, Detective Inclan asks her the name of her brother, and her voice noticeably softens. And she's been talking like this, and then she says, Alex. So she's got a soft spot for him. I don't know. I think she views him as her protector and her helper. And I think she views it in the light that he gave his life to serve this cause, and which just disgusts me. So there's that. Natalie Cassidy, Megan, do you believe that Megan was the one that told Alex where? Do you mean Melanie? Because I definitely did not tell Alex anything. Yes, I do believe that Melanie was the one that gave away the address. I think she was the only one that had it. But again, that's allegedly. We're going to wait for the proof in the trial. Yeah, she did mean Melanie. Thank you. Appreciate that. It was not me. And then why do you think Judge Beresky's been so patient with Lori? Well, the reason why I think he has is because he doesn't want a mistrial. I think he wants to be as fair as possible and give her like he said, over accommodate her so that she can't then go back and claim, as she already has, that there was some kind of bias or prejudice against her. I think he has on the record shown an extraordinary amount of patience, and he has shown an extraordinary amount of accommodation for her. And I think he's done it so that she can't then go back and say, get an appeal based on that. So I do have one more thing that I'm going to address what I talked about originally at the beginning of the video, just to say what my video is going to be about tomorrow. And I am going to play a little 3-second outro that I think you'll appreciate, guys. So I appreciate you being here. If you're here, please like the episode and please share it with somebody who you know wants to hear this information. This is a recap of all the motions prior to next week, jury selection coming up on the 29th. That is just 1 week away, 6 days away. So next Thursday, we're going to be back in the courtroom for jury selection. And that's an important part of the trial. I was so glad that I went last time to jury selection because I wanted to know. I learned so much. The questions that were asked the jury and their responses surprised me in a lot of ways. So I definitely want to be there for that. And I definitely want to report on it. So I will be there. I will be there for that. Let's see where I left off here. Maybe if we do that, you can focus on questions. Oh yeah, the emojis, that would help. That would definitely help if you guys had emojis, but if you do the red question emoji, yeah, that would help call attention to it because I'm definitely a visual person. I appreciate that. Lori did claim in an interview she was teaching classes. She did teach some Zumba classes or something like that. But that was all she was doing. And I made a comment the other night. Imagine if all of your expenses were paid for, your housing, your car, your food, all of that was paid for, and you got a $4,000 allowance. Charles told Lori that's what she would get. He told her you can still have your $4,000 of spending money every month, $4,000 a month to go out to lunch with your friends, to buy clothes, to travel to Hawaii. And all you have to do is be a good mom. That's all. Imagine giving that up for Chud Dumbbell and his terrible books. I can't imagine it. She also did say she was teaching exercise classes to the ladies in her group. But somehow I think everyone who's an adult knows how to exercise. Yeah, but it's not as fun if you don't have dancing and choreography to go around with it. Yeah, 2020. I haven't watched that episode. I don't know. Should I? Melanie B., how does she make her living? I believe that she is a woman of leisure. She takes care of her children. I shouldn't say that. She takes care of her children as far as I know when she has custody of them. But I don't think she has a profession, which there's nothing wrong with that. And being a wife and a mother is a full-time occupation, because if you're keeping a house and you're keeping up with your kids, trust me, I know as a mom of 6 kids that keeping track of all of their clothes and food and lunches and extracurricular activities and permission slips and homework and all of that stuff, that is a full-time job, especially if you're also taking care of the house and cooking the meals and doing the shopping and all of that. But I don't think that I don't think she works outside of the home. This is an interesting comment. I think that's probably true. SP Mama 444. I don't know exactly, but I want to say 5'3" is what sticks in my mind. I'm just not positive about that. Thank you for this. On a 2-door vehicle, seat folds forward to allow people to get into the back. That is true. So if that seat was folded forward, Alex was laying on the back, allegedly on the floor in the back, he could have quickly pulled the little lever underneath that front seat and moved it back into driver's position and jumped in there. I don't know. It's possible. I'm looking forward to the evidence so we can stop speculating. Joe Tall Chief says Colby said Lori had Botox and fillers. I don't doubt that. I don't doubt it at all. Scottish Lass 222. Scottish Lass. Good to see you. 222. Lake Tahoe is so beautiful. I can't wait to get up there. I'm hoping to get up there this summer when I visit my daughter and my 2 grandsons. I'm excited. Yes, Beresky also asks her every single time he rules on something, do you understand? Just to make sure she totally understands everything. KK, just trying to look for more questions here. Flee the state in the middle of the night. So she pushed back a little bit on this. I don't know what is correct on this, but what Melanie says is that she did pack up the truck during the day. She did discard some of the kids' items that she wasn't taking with her, but she pushes back against the fact that she fled in the middle of the night. She said it was pretty quick that she left, but anyway, let the evidence bear it out. Excuse me. How to help people. SP Mama 444. There needs to be a how to help people in a cult see the light of day, asking logical questions and being a help and a comfort to that person without being pulled into the belief. Yes. And if you go to freedomofmind.org, Dr. Stephen Hassan is an expert on cults, and he has a lot of information there for family members of people who they believe are being pulled into a cult, of how to handle that properly so that the cult person doesn't just double down on their beliefs. And he talks a lot about his own story. He was in the Moonies, and he talks about what got him pulled out and what his family did and said in order to help. There's a ton of information there, as well as some courses. And if you're a mental health professional, there is continuing education on how to help people who have been duped by people like this, cults like this. So I highly recommend Freedom of Mind Institute and the BITE model. Dr. Hassan has written a couple of books on this as well, and I can't recommend them enough. I've taken his course on combating mind control, and it is fascinating and also extremely helpful. That's true. Mohawk Mom, Brandon said there were only a few people who had his address, and Melanie's was one of those. Getting down to the end here, you guys, just trying to make sure I didn't miss anything that was really important. Oh yeah, red question emojis on a laptop, not on phones. Yeah. Yeah. 4K a month was her allowance that Charles gave her. And imagine getting upset about that. Aaron says, I have them on my iPhone, but I agree it's a bummer. Apple doesn't let us join memberships very easily. Yeah, it's hard. I'm sorry, you guys. I tried to fiddle with the settings as much as I could for the memberships. And the membership here on my channel at YouTube will get you early releases of videos. It will get you some bonus content, some members only lives. But the majority of my bonus content is over on my Patreon at the Midlife Revolution. And that is where I share some of my more personal things, personal pictures. I perform some music and songs over there, and I do some cooking and recipes. So if you're into that kind of bonus content, that's where you can find it. And I appreciate all of you who support me on Patreon. Lori didn't even cook. Yeah. I mean, she made her green chili enchiladas, I guess. Some of these comments, I guess, are you guys have been in chat having other side conversations, so I don't know what you're talking about, but I'm trying to answer as best as I can. Do you think Emma Daybell is in contact with Lori? You know, Emma seemed so enamored of Lori during those videos that we saw of Emma talking to Chad on the day he was arrested. And I believe in her testimony in court, she seemed like she still was kind of pro Lori. So I don't know where she stands now. I would hope that she has been disabused of some of her notions about Lori being a good person, but I don't know. Like, it's really hard when you're brainwashed by your own family to go into anything that contradicts that. It requires a psychological break of some kind. So I don't know. KP, I just meant how she pay for all of her bills, raising children, food. I know that's very expensive. Is she on welfare? I'm too nosy, I think. Well, she is married to Ian Pulowski. I think Ian makes a good living. And I do think that Brandon pays, some contribution for child support. I don't know if their custody is 50-50 or if it's just shared where it's every other weekend. I don't know the exact timing of the custody. So if it's only every other weekend, it could be that he only pays a small contribution of child support. And I think she did get some money from the settlement and the divorce, although I don't know how much of that went to Lori, and the sale of the home as well. So I have no idea what the real financial situation is there. I think it's pretty complicated. Lee T, do you see patterns in Lori that are similar to Barry? That's a big impression I got about Lori after your show on Barry. Yeah, I do see patterns in Lori. That it's that sense of entitlement. It's the belief that she's above the law, all of those things. LC, I don't know who you're talking about. Does he take care of conspiracy theories too? I don't know who the he is that you're talking about, so I'm sorry about that. Natalie, just wondering how your grandson is doing. He's doing really well. His jaundice is completely gone. It seems like he is digesting things well now. I don't think we have any more answers about the genetic testing, but he seems to be doing well and thriving. So thank you for asking, and I'm grateful he's doing well. Maybe they let her put some mirrors in herself for dancing. Yeah, Emma did dye her hair at one point when she showed up at the Chad Daybell trial. She showed up looking a lot like Lori. Yeah, mothers are house managers. We just don't get paid by dollars. It's about time that's an actual paid position, house manager. I agree. Ooh, I did not know this. Brandon Boudreaux gave her $300,000 plus half of his company's money. That's a lot of money, you guys. Yeah, I knew that she got something in the hundreds of thousands of dollars in the settlement and the divorce. So, yeah, this is so true. Yeah, I forgot about it. Google owns YouTube and they have a beef with Apple. That's why Droid people can join easily and iPhones can't. I'm so sorry about that. But that's good to know that that's the reason and it's not just me. Oh, the doctor that I mentioned. Now I forgot the question though. Shoot, I lost it. Does he take care of conspiracy theories too? Oh, he does address, Dr. Hassan, he does address some conspiracy theories, but I think his expertise, his specialty is much more in the vein of of the cult mindset and brainwashing and indoctrination. I think Lori's greatest fear about the upcoming trial is that she's not going to find out what everybody said about her. I think that's all she cares about. She doesn't care about the conviction. She cares about looking bad. And I think that's probably her biggest fear. Okay, so on the outro, I'm going to play just a little 3-second clip I think you'll like. I hope you'll tune in tomorrow for the video that I do in defense of Jenny Gage against Ward Radio. Jenny Gage is a content creator. She has a channel called Life Take Two. She's privatized her TikTok now because of all of the bullying that she's received. And she recently got dragged on 2 episodes by a channel called Ward Radio that's a faithful Mormon channel. And they claim to be followers of Jesus Christ, but I think the way that they've treated a former domestic abuse survivor is despicable. And so I'm going to have Jenny on my channel. We're going to talk about domestic violence. We're going to talk about online bullying of content creators. And we're going to talk about the fact that there is this rift between Mormons and ex-Mormons that should not be. Content creators should not be dragging each other just because they disagree with each other's points of view. And I think it is unconscionable what's been done to her. And she is having a mental health crisis due to all of the online bullying that she's receiving. And Ward Radio basically took advantage of that and ran with it at a time when she's particularly vulnerable. And I think it's disgusting. So I'm going to address that tomorrow. I hope you guys will join me for that. Lori Kennedy asked, Megan, do Barry and Janice live behind a gated community? You never see them being followed by the news. I don't know if they do live in a gated community or not. I would be willing to bet that their house is not in their own name, though. So it might be hard to find them. I think I have their address, but I would never dox them that way. And I don't see what point there would be for news media to follow them around. They're not going to answer any questions. They're going to say no comment. They don't want to be involved, clearly. They haven't been at any of these trials or hearings or anything like that. So it's very clear that they don't want to be in public. And anyway, that's all. So I hope you guys have a fabulous evening. Go over to Web Sleuths. I know they're going to be covering some of this as well. That's where I'm going to go, and I will see you in chat over there. Thanks for being here tonight, beautiful humans. Please take care of yourselves and have a beautiful evening. I'll see you tomorrow.
Are you done? Are you just going to keep